Now we get to the heart of the argument. Does the power to regulate include the power to tax?
I want to make a very important distinction here. We don't contend that what's being exercised here is the power to tax. It's the power to regulate foreign commerce. These are regulatory tariffs. They are not revenue-raising tariffs. The fact that they raise revenue is only incidental. The tariffs would be most effective, so to speak, if no person ever paid them, if they achieve their goals.
Remember, when we define the word tariff, a tariff includes both the list of items and the duties that are to be imposed on them. A duty is a tax. With respect to the laws relating to customs duties, a tax owed to a government for the import or export of goods. Now, there is no such thing as a non-revenue-raising duty. So there's no such thing as a non-revenue-raising tariff. So General Sauer's statement is just plain nonsense. Justice Sotomayor made this exact point.
I just don't understand this argument. It's not an article. It's a congressional power, not a presidential power to tax. And you want to say tariffs are not taxes, but that's exactly what they are. They're generating money from American citizens, revenue. And you say it's incidental to the regulatory purpose. But I don't see how a quota is equivalent to revenue raising. A quota sets a limit to what you can import in, but it doesn't generate revenue.
Then Justice Barrett asked the very question that is at the cornerstone of this case.
Sauer, can I just ask you a question? Can you point to any other place in the code or any other time in history where that phrase, together, regulate importation, has been used to confer tariff-imposing authority?
Well, as to regulate importation, that was held in TWIA. So obviously, and that's...
Okay, so an intermediate appellate court held it in TWIA, but you just told Justice Kavanaugh that wasn't your lead argument, that your lead argument was this long history of the phrase regulate importation being understood to include tariff authority. So my question is, has there ever been another instance in which a statute has used that language to confer the power? Well, putting aside Yoshida.
I mean, obviously, other statutory example is just imports. The cases we rely on are cases where, for example, in Gibbons, it's Ogden and Justice Story's
But that just shows the word can be used that way. None of those cases talked about it as conferring tariff authority. I understood you to be citing McGoldrick and Gibbons in those cases just to show that it's possible to say that regulating commerce includes the power to tariff.
So apparently, no law, no statute has ever implied that the power to regulate included the power to tariff or tax. Even General Sauer's attempt to answer shows the weakness of this argument, since the only thing he can point to are court cases that, according to Justice Barrett, do not show that regulating commerce includes the power to tax.
Because the natural understanding of regulate, even though, in fact, we can regulate through taxes, but when the code uses regulate, we don't typically understand it to refer to duties or taxes or tariffs or anything of the kind.
If the power to regulate includes the power to create duties, why is the power delegated to Congress to lay and collect duties separate from the power to regulate foreign commerce? Since the Constitution separates those powers, placing the power to collect duties in Clause 1 and the power to regulate foreign commerce in Clause 3 of Article 1, Section 8.
So yes, sure, the tariffs are a tax, and that's a core power of Congress, but they're a foreign-facing tax, right? And that foreign affairs is a core power of the executive. And I don't think you can dismiss the consequences. I mean, we didn't stay this case, and one thing is quite clear is that the foreign-facing tariffs have in several situations.
Right, and we are.
I'm sorry. Were quite effective in achieving particular objectives. So I don't think you can just separate it when you say, well, this is a tax to Congress's power. It implicates very directly the president's foreign affairs power.
Yeah. Mr. Chief Justice, we don't disagree with a large part of that. We think instead of thinking about foreign versus domestic, the better way of thinking about it is Article 1 versus Article 2. And as my friend finally conceded to Justice Gorsuch, there is no Article 2 power here, at least when we're talking about peacetime.
Except, as both Justice Kagan and I have already pointed out, there is no foreign affairs powers delegated to the president, not in Article 2, nor in any other clause of the Constitution. The fact that Chief Justice Roberts thinks they are effective doesn't make them legal. Well, Chief Justice Roberts doesn't seem to get this. Justice Sotomayor does.
Well, I think what we're forgetting here is a very fundamental point, which is the Constitution is structured so that if I'm going to be asked to pay for something as a citizen, that it's through a bill that is generated through Congress and the president has the power to veto it or not. But I'm not going to be taxed unless both houses, the executive and the legislature, have made that choice, correct?
That's exactly right.
So there is something, it's not just the taxing power, qua taxing power. The question is, do we permit the president to use the taxing power to affect his personal choices of what is good policy for me to pay for?
That's exactly right. The question is who decides.
Taxes are imposed by the only branch of government elected by the people to represent the people and the states, Congress, not the president. In fact, the framers of the Constitution went a step further, where they stated all bills for raising revenue shall originate in the House of Representatives.